evening, everyone. It's 6:01. We'll go ahead and start the meeting. Let's please take a row.
Commissioner Lide, Commissioner Diaz,
Present.
Commissioner Bray, Commissioner Wagner,
Present.
Commissioner Kreiner,
Present.
Vice Chair Hardy,
Thank you.
and Chair Vane.
Here, thank you. Well, now, everyone, please stand. We'll go ahead and start the Pledge of Allegiance. Ready? Begin. I will now go ahead and read the procedures for the meeting. This meeting is being conducted in person and electronically. The public may participate in tonight's meeting by using the Zoom link provided on the Planning Commission agenda. Please note that all virtual participants will be on mute until they are called upon by the chair, at which point they will be unmuted. If you're a member of the public and would like to comment on the item, use the raise hand function on Zoom. To avoid any confusion, please wait for the item you desire to comment on to be called by the chair before electronically raising your hand. For each matter considered by the commission, there will first be a staff presentation, followed by a presentation from the project applicant. Testimony from supporters of the project will then be taken, followed by testimony from those in opposition. The applicant will have the right to a final rebuttal presentation prior to closing the public hearing. In accordance with Section 13 of Article 2 of the Planning Commission Rules and Regulations governing length of public debate, all public testimony from those in support and in opposition of the project will be limited to 3 minutes per person. The 3 lights on the podium next to the microphone will indicate the amount of time remaining for the speaker. The green light will be turned on when the speaker begins. The yellow light will come on with the self-bell ring when 1 minute is remaining. The speaker should be completing testimony by the time the red light comes on, with the final bell indicating time has expired. All in-person public testimony must be presented to the commission at the podium. Any testimony that references race, religion, ethnicity, economic status, national origin, or any other classification protected under state or federal law in a derogatory manner shall be deemed irrelevant and will not be considered by the commission in making its land use determinations. If you challenge these land use matters in court, you may be limited to raising only those issues you or someone else raised in oral or written testimony or before the close of the hearing. We'll start today's meeting with the approval of the agenda. Are there any changes to the agenda?
Good evening, Chair, members of the Planning Commission, Israel Trejo, Planning and Development Department. There are no changes to the agenda. Thank you.
All right, perfect. Do we have a motion to approve the agenda?
I'll make a motion to approve.
Okay. We have a first motion by Commissioner Wagner. We have a second by Commissioner Diaz. All in favor say aye. Aye. All opposed say no. Motion passes. We'll go on to the reports by commissioners. Do we have any?
I just want to take a moment to congratulate the Marjorie Mason Center's top 10 professional women. They had a very nice event today at the Convention Center honoring those that have contributed both to Marjorie Mason and the community as a whole. So excellent event, and wishing them all the best as they build out their new facility.
Thank you. We'll move on to continued matters. We have ID 231514. Continue from October 4th, 2023. This is for the consideration investing tentative track map number 6346. Do we have the staff going to be presenting on Zoom? Okay.
Yes.
Okay, good evening, Commission. Can you hear me just fine? Can you see everything just fine?
Yes.
Thank you. My name is Rob with the Planning and Development Department, and tonight staff brings forth consideration of vesting tentative track map number 6346 and related environmental assessment. The subject property is located at the north side of Princeton Avenue between North Bliss and North Fowler Avenues. The immediate properties to the north include a recently approved 71-lot single-family gated subdivision. And then on the western half of that northern area would be a drive-through fast food restaurant and a commercial retailer. The immediate property to the west is a wholesale and distribution business. To the east and south are single-family residential neighborhoods. The project site received previous approval in 2020 for 90 multifamily dwelling units. The residential density for that complex is 18.11 dwelling units per acre, which provides consistency with the urban neighborhood plan land use designation, allowing for between 16 and 30 dwelling units per acre. And the development standards were complied with in terms of parking, setbacks, landscaping, et cetera. Tonight's map is just a one-lot subdivision for purposes of authorizing a condominium map for the previously approved multifamily development project. And that said, staff's recommendation is to adopt the environmental assessment and approve the map. That concludes staff's presentation. I'd be happy to answer any questions you may have.
Thank you very much. Do we have any questions from the commission? Thank you. We'll go ahead and move forward with the applicant. Do we have the applicant on Zoom or?
I believe Drew Phelps should be available.
Good evening, Chair Vang, Commissioners. This is Drew Phelps here with Granville Homes, 1306 West Herndon here in Fresno. Staff's report pretty much laid it out. This is a straightforward proposal. As you even saw from the aerial photograph shown in the presentation, the project is actually already under construction, and we're really happy to be moving forward with this. It's an exciting project, but I'll keep my comments short. We previously continued the item because we did have an issue on one condition in particular regarding CFD 18 that was sorted out with actually the track just to the north, track 6366. That issue has since been resolved, and so we are happy to request approval with all the conditions that staff has placed on the map. Of course, I'm here to answer any questions if the commission has any. Thank you.
Thank you very much. Do we have any questions from the commission? I see none. We'll go ahead and we'll go out to the public. Are there any members of the public who wish to comment in favor of the application? Do we have any individuals with their hand raised on Zoom?
Not at this time.
Okay. We'll go ahead and move forward with any members who would like to speak in opposition. So if you're in opposition, please raise your hand on Zoom. Do we have any individuals?
Not at this time.
All right. Perfect. We'll go ahead and close all public comments. We'll bring it back to the commission. Do we have any comments, questions, or any motions?
I'll make a motion to approve.
Okay, we have a motion by Commissioner Wagner. Do we have a second?
I'll second.
Second by Commissioner Kreiner. All in favor, say aye. Aye. All opposed, say no. None. Motion passes. Next, we'll go ahead and move to new matters. This is going to be a workshop on how to read and use the development code.
Good evening, Chair Vang and Commissioners. Jennifer Clark, Director of Planning and Development. We have a workshop tonight to talk about the development code, which is our implementing ordinance for our zoning here in the city of Fresno. So I will be starting it off, and then I'm going to turn it over to Phil Segrist, current planning manager, and then he will turn it over to Israel Trejo, also current planning manager, who will turn it over to Christy Costa, our city attorney, and then back to me. So we anticipate that this workshop will take about 20 to 30 minutes, but we really wanted to spend some time talking about the ordinance that drives how we review applications here at the city of Fresno. And then we'll drill down a little deeper in some of these sections as we feel like you have interest and that there's a need based on applications that are coming before you. So just kind of kicking it off. Here we go. So what is the development code, right? So when you all came on board, you got this lovely binder, right? And I know that you have spent many countless hours reading and enjoying this piece of work right here, right? And the development code is really the rules that guide how land use establishes in the city of Fresno, right? So we talk about certain rules whether it's setbacks or heights or the type of use that can be there or the kinds of findings that you need to make. That it's all found right here in this book. So the development code really is the implementing tool to help development occur within our city. It establishes not only our zone districts, permitted uses, use regulations, and development standards, but also the procedures, the way in which we can operate. So how is it broken up? So there are essentially 5 sections. So there are, these are the 5 types of things that are in the code. So we have use regulations. So that's going to be what kinds of activities can happen on a piece of property or in a building. It's going to have development standards. That's the how. That's the how those particular uses can occur. How many parking spaces do they need? How tall can the building be? How far does it need to be set back from the curb? How many trees do you need? Someday, my husband has always asked that I do a Monty Python skit called Bring Me a Shrubbery. And it's based on the landscape requirements, but really that's what it is, right? So development standards are those specific requirements. Land division is really state law. How can we divide up property legally within the state of California? Administrative regulations, those are the things that define who can do what, who has the authority to do what, and how do they go about doing that. And then terms and use classifications. So we're going to start out, and I'm going to go over kind of the first section, and then I'm going to turn it over to Phil to talk about base and overlay districts. So the code is really divided into these 6 sections. We have general provisions, base and overlay districts, regulations that apply to some or all districts, land divisions, administration and permits, and general terms and definitions. And those are really the parts of the code. So when we say, chapter 15, that's this whole book, part something or other, right? Those are the parts. Article, those are then the next subsections, and then the numbers. So everything in the code is numbered. So general provisions. So I'm going to talk a little bit about general provisions. So general provisions are really important to kind of lay the groundwork for how do we use the code. So essentially, the purpose of the development code is to implement the general plan for the public health, safety, peace, comfort, convenience, prosperity, and general welfare, right? And then there's a long list of kind of the why we're going about doing that and how these rules help us get there. So the introductory provisions really talk about what is the purpose of the code, what are the state laws that regulate what and how we do, and then kind of a basic layout of the base districts and the uses that are permitted. Then there's rules of construction of language, right? It tells us as staff and you as commissioners, what does it mean when it says and in a section? What does it mean when it says and/or? What does it mean when it says or by itself or either or, right? So how do we use that as when we're implementing, when someone comes in and applies to build a building in the city of Fresno and it says you can do this or that? How do we know which piece that we have to apply to that particular to that particular section, right? So it tells us what the words mean in the code, and that's really important because a lot of times you'll see something where we'll have someone say, well, I didn't think I had to do that, right? I thought it was or, but maybe it said and in the code. So that helps us define that. Then there's rules of measurement. Do you round up? Do you round down? When do you round up and down, right? When is a percentage used or a fraction used, right? So rules of measurement. How are things measured? Where do you measure? Where's the line? Is it from back of curb? Is it from the property line? How do we measure when we're actually determining, is it the appropriate distance or separation from another use or from a particular place on the particular parcel? And then probably the section that I personally use the most, and we spend a lot of time in my conference room talking about, non-conforming uses, structures, site features, and lots. So this section is really important when we're applying rules to a property where there's already a building or already a use there that was approved a long time ago and they've continued to operate, or the building is still there, but it's no longer what we would consider a permitted or a conforming use. Maybe the building is too close to the sidewalk, or maybe the sidewalk is too small, or maybe the use isn't allowed in that district anymore. We spend a lot of time really reviewing this and making sure that we're making the right call when an applicant comes in and wants to use a property in a way that it's been used in the past, but it may no longer be allowed to be used. And you've actually, I've done, I've spent some time here in this chamber talking about how do we apply non-conforming use standards in certain situations, and are there ways through maybe an overlay or a text amendment that we could clarify and make it easier for businesses or property owners to continue to use their property. So that's a place where I personally spend a lot of time, and we spend a lot of time as staff, and I think is one of the more complex issues in the code. And with that, I'm going to turn it over to Phil, who's going to talk about base and overlay districts.
All right, thank you. Philip Zegras, Planning Manager. So again, part 2 of the development code, it covers base and overlay districts. And this part is comprised of various articles, and each of which covers different base zone districts. And that would include your single-family residential districts, multifamily residential districts, your commercial, your industrial, or the employment. And furthermore, within each article for a base zone district includes use regulations, as well as density and massing development standards, site design development standards, and design development standards. And for the use regulations, within each article, they specify which land uses are permitted, conditionally permitted, or specifically prohibited in each zoning district. And it also includes special requirements that may be required for specific uses. And without getting into details, within the use regulations, there are use regulations tables, which will list various uses and show their permissibility, whether they're permitted with a P, conditionally permitted with a C, or not permitted at all. Then further on in the article are the density and massing development standards, and those provide regulations which control the height, as well as the bulk, location, and appearance of structures within each zone district. And they're really kind of telling how buildings can be built, how far they need to be set back. And also similar to the use regulations, there's also tables that identify that it's easy to read and shows what the setbacks are, if it's a maximum, minimum, for frontage, coverage, what have you. And then following the regulations and development standards tables, it dives a little bit deeper with site design and facade design development standards. And again, it just kind of provides various residential transition standards for certain uses, which might have certain setback requirements if you might have a commercial use adjacent to a residential use, as well as other standards for pedestrian connectivity if you have a commercial use adjacent to sidewalks. It really kind of goes into the specifics, and on the current planning end, that's a lot of the stuff that we tend to deal with when reviewing site plans. Next slide, please. Okay, and for overlay districts, this is a zoning designation specifically delineated on the zoning map, establishing land use requirements that govern in addition to the normal standards set forth in the underlying base zone district. And they're typically combined with the base district and provide special development standards with the intent of preserving specific areas and resources, such as bluff areas, as well as protecting uses and residents proximate to major thoroughfares, such as the expressway area overlay. And there's also, they also intend to preserve and enhance existing patterns of development, such as the apartment home overlay, which you'll commonly find within Tower District along with Shawn and Van Ness. Next slide. Okay, regulations applying to some and all districts. These regulations are included in Part 3 of the Development Code, and they're comprised, again, of several articles, 8 total. And furthermore, this section covers certain regulations that are applicable to some and or all zone districts, as well as performance standards which govern certain special uses. And examples would include your general site regulations, transit-oriented development and density bonuses, affordable housing density bonuses, landscaping, parking, performance standards, et cetera. All right, and general site regulations. So this is identified in Article 20. This applies standards which are to be used in conjunction with the standards of the regular zone district. And it's important to note that in the case of a conflict between the normal development standards and the standards including in this section, the more strict regulation would apply or would prevail. And examples of general site regulations include trails, screening between differing land uses, fences and walls, as well as trash collection areas. Is just a few of the many. Next slide. Transit-oriented development, otherwise known as TOD, height and density bonuses. Those are included, addressed in Article 21. And this section provides flexibility for projects which promote walkability, livability, and transit ridership near bus stations and bus rapid transit and other enhanced transit service. And under this section, qualifying projects may be granted height or density bonuses. Next slide. And similar to Article 21, Article 22 addresses affordable housing and density bonuses and provides for the granting of density bonuses for qualifying projects over the otherwise allowable maximum residential density permitted by the code. Furthermore, the purpose of this section is to lessen the shortage of housing affordable to moderate, low, and very low-income households in the city, as well as implement policies of the housing element and establish requirements for the resale and rental controls to ensure those units remain affordable for at least 30 years or another time specified by the city. And next slide, please. So landscaping. Landscaping is included as, again, another article, article number 23 to be specific, and it's intended to enhance the appearance and the function of all development by providing standards relating to the quality, quantity, and design of landscaping. Furthermore, this article is intended to protect the public health, safety, and welfare by minimizing the impact of that's a lot to read, but I don't want to go into the details of what's on that slide. But again, the landscaping section just provides general landscape requirements, what your landscape setbacks need to be, how many trees need to be provided on a site. And next slide, please. Similar to landscaping, there are parking and loading requirements, and these are identified in Article 24. And the section's intended to minimize design impacts from parking lots, and also provide other flexible means for minimizing the amount of area developed, and really so we don't have just all parking, less building space. And the article includes those standards and requirements for the base zone district, as well as it addresses access to parking spaces, how parking spaces or parking lots are lighted, as well as surface standards for those parking lots. Next slide. And performance standards, again addressed, not again, but in Article 25, this section is intended to establish permissible limits and allow objective measurements of nuisances, hazards, and objectionable noise, as well as ensure uses provide control measures to protect the community and from nuisances and hazards. Subsections within this include noise, vibration, lighting, odor, hazard, liquids, and solid waste. So again, this is really to ensure that as properties are developed, that by following these guidelines, that they are not going to have any nuisances or adverse effects on surrounding properties or uses. Going into the signs section, this is included in Article 26. And again, this just in general covers all signs. When permits are required, also addresses which zone districts allow certain types of signs, whether or not a monument sign is permitted or a pole sign. It also regulates the size of signs, based on the overall square footage of a building facade. And next slide, please. And last for my section is Article 27, which addresses standards for specific uses and activities. And the primary purpose of this article is to establish standards, again, for those specific uses, which may be permitted or conditionally permitted in some or all districts. And really within this district, examples of specific uses are going to be adult-oriented businesses, alcohol sales, both on-site, such as liquor stores, as well as eating and drinking establishments, bars, restaurants, and nightclubs. Others that we'll commonly see are drive-throughs, service stations, and again, within each one of those subsections are various development standards where a certain use might not be permitted within a certain proximity of another use, or a drive-through needs to be developed or can't be developed between a building and the back of a sidewalk. It just goes into that detail that the base zone districts don't provide that level of, specificity. That's not a right word. Doesn't really get down to the details of the specific development. And after that, I will turn it over to Israel.
Good evening again, Chair, members of the Planning Commission, Israel Trejo, Planning and Development Department. So my section, my portion of this workshop is the land division section. So as Jennifer kind of alluded to earlier, we can spend hours, if not days, on each of these sections, but try to go through, just a couple of examples through each section. So the land division section of our development code is Articles 31 through 35 of the development code. Those include general provisions, required maps, parcel maps, tentative tract maps, dedications and reservations, lot line adjustments, so on and so forth. So I just want to briefly touch on each of these sections. So general provisions, what does that mean? So the way our code is written, especially the subdivision section, it's written in a manner where a mom and pop subdivider or a subdivider that's been in the business for 20 years understands clearly what the rules and regulations are. So, it goes over approving authority. Who approves an application? Is it the director level, or is it, as you saw today, the Planning Commission? So Planning Commission approves tract maps. Also discusses when a map is required to go to the Subdivision Review Committee. Subdivision Review Committee is a committee that's made up of city representatives as well as outside agencies, and a project would go to that committee, the more complex projects. So a subdivider wants to know up front, hey, are there any issues, major issues that are going to require wholesale changes to my project? And again, the internal agencies as well as outside agencies meet with the developer, and we go over those types of issues. So that's the general provisions. Required maps. So again, this section is very straightforward, very elementary. So required maps. So 4 lots or less, a parcel map is generally required. More than 4 lots is a tentative tract map. So you can have a 4-lot residential subdivision that would be approved at the director level. More than 4 lots would come to you at the Planning Commission. Next is tentative parcel map and tract map filing and processing. Again, you're gonna hear me say this a lot. It's the way the code's written is so, you have a mom and pop developer or someone that's been in the business for years. They understand what the rules and regulations are. So the processing would be, an application is accepted, gets routed to various departments and agencies, staff writes up the conditions, and if it's required to go to planning commission, staff report is written, as well as public noticing. Vesting tentative maps, that's really just the definition sections. Basically, if a map is vesting, what that means is if it was approved, or rather, the rules and regulations that it was approved under, if it changes and the map is not built, since the map is vesting, they're still allowed to build under those rules and regulations under which it was approved. These next two sections, parcel maps, final maps, kind of go together. When developers come in, the way I like to explain the process is it's a two-step process. So step one is get their tentative map process approved, and that's what we saw tonight for the condo map. That's kind of step one. And step two is the final map process, and Harmon here and Public Works processes final map. So what he does is he takes all those conditions that have been compiled in the package staff report, and he makes sure all those have been complied with prior to recording the map. Much more difficult than that, definitely simplified it, but that's essentially the process. Dedications and reservations, so there's a lot that goes into a map and what's shown on it. So there's streets, there's alleys, there's easements, there's trails, and all those different components of the map are required to be dedicated as easements with when the final map is recorded. Improvements and security, so that's, what article is that? That's Article 38 in the Development Code. And I've always been amazed at how, you can take a plot of land, one day, and a year later you'll have a subdivision there. So basically that section goes over improvements and security. And basically, different improvement plans are submitted to Harmon. Those include street plans, utility plans, lighting plans, landscape plans, so on and so forth. So that section goes over those different plans that are required. Common interest developments, we did see a map tonight. It's a condo map. So there's really two flavors of condo maps. You have the condo map that we saw tonight, and then we also have conversions. So a conversion is when the multifamily complex is existing and a developer decides to convert that into condos. So basically you go from one owner to many owners to the condo map. And the rules for conversions are much different than for the map that you saw tonight. So for conversion, the people that are living there, they have first right to buy those condo maps. Also, I want to say, I think if they're sold, if they don't buy, I think they get 6 months of rent to their new place that they move to. Subdivision design standards, that's kind of the recipe I like to call for subdivisions. It goes over, there's probably a 3 or 4 page list of different designs for a map. Includes adjacency, so if you have a 10-acre parcel and you're developing the 10-acre parcel and your neighbor is 10 acres to the east, but they're not developing, the code requires connectivity, connection streets. Also goes over length of streets, lot sizes, block size, open space, so on and so forth. Some of these next sections are kind of simple processes in planning and development. They also in Harmon's shop in Public Works, lot line adjustments, mergers, and reversions. So lot line adjustments, that comes from the MAP Act, and basically you can take a maximum of 4 parcels and adjust those. You can't create more parcels, but you can lessen or stay the same. So if you have 4 parcels, you can adjust those to fit your development. Merger is kind of, as the name implies, you're merging parcels, removing property lines. So if you have two properties and you want to build a structure over that property line, you file a merger to remove that line. Reversion, I've been here over 15 years, and I think I've seen 1 reversion here in the planning department. That was before my time. We don't see a lot of those. Basically what that is, it's a map that has been recorded, but for some reason the developer decides not to move forward with the subdivision, and it's, as the name implies, reversion. It reverts back to acreage. So instead of going from, many lots, it reverts back to, one 10-acre parcel. Corrections and amendments of maps. So we'll often see, so we have two types of revisions. We have minor revisions and major revisions. The minor revisions, as the name implies, are just minor changes to a map that aren't required to come back to the Planning Commission. It's approved at the staff level, say a street radii or a property line, something minor to an approved tentative map by the Planning Commission. The developer wants to make a change. That's a minor revision. A major revision is if a developer wants to add lots, or if there's something in the opinion of the director that is a major revision, we can classify it as that. And there's two methods, ways the director can approve that. Either she can bring it to the Planning Commission for basically informing the Planning Commission that she's making that change, or she can, if the changes are significant enough where she wants the Planning Commission to approve that change, the director can refer to Planning Commission. Enforcement and judicial review. So what that is so the City of Fresno adopted the MAP Act in 1968. So prior to 1968, if you had a piece of property and you want to sell it to your neighbor, you can do that without a parcel map. You can do that with a deed. But after 1968, if I wanted to sell a piece of my property to someone else, I had to file either a lot line adjustment or parcel map. Basically what this section is if there's a change in land ownership that wasn't compliant, this section goes over how you rectify that. Last but not least, surveys and monuments. We don't deal with that much. That's Harmon's shop, but basically that's the metal stakes that are placed at the corners of the property. Thank you.
Good evening, Commissioners. Christy Costa, City Attorney's Office. I am covering administration and permits. Next slide, please. So, talking about planning authorities, there are several bodies within the City of Fresno or officials that have various responsibilities when it comes to the development code. Depending on the land use administration procedure being utilized, some or all of these bodies will or could be involved in the process. So actually starting from the bottom, the council district project review committees, they will provide generally recommendations to this body. They are only involved if the code defines that they are involved. So everything that in this process is in the development code. So they will provide recommendations to the Planning Commission as well as council on applications for plan amendments, rezones, maps, CUPs, plan development permits, or variances. They essentially allow the citizens of specific districts to have input into what happens within their districts. The Historic Preservation Commission, they are actually codified under Article 16 of Chapter 12 of the Fresno Municipal Code, which is the Historic Preservation Ordinance. And their duty is to identify, designate, and preserve historical resources in historic districts owned by the city or located within the city limits. So all things historic, they are involved. Then we have the director, Ms. Jennifer Clark. She and the planning department in general maintains and administers the development code. So they're really your first level of review on all things development code. She ensures permits and discretionary approvals are followed, the proper administrative procedures are followed, and that all aspects of the development code are being complied with. The director will make the initial CEQA determinations, so environmental assessment, whether a project is exempt or, has a mitigated negative neg deck is what we call it. If something is appealed to the Planning Commission or needs to come to the Planning Commission, the Planning Department will make recommendations. You've heard those before. They make recommendations for approval or denial based off of findings that can or cannot be made. Let's see here. And then they also make recommendations to the City Council for anything that goes before the City Council. The Planning Commission, you all. You have various roles as well, again, defined within the municipal code. You make decisions on land use entitlements, decide if projects are consistent with policies of design and performance standards. You review implementation of the general plan and make recommendations to City Council if necessary. With regard to changes, you conduct hearings and make recommendations to City Council on proposed amendments to operative plans, to the general plan, to zoning maps, development code text amendments. You've had several of those come before you as well. You make environmental determinations if they come before you as well on appeal, and then conduct hearings and make recommendations to City Council on proposed permit revocations. I don't know if you've ever heard a revocation request. Anybody recall? No, they don't happen very often, so. And generally just hear appeals pursuant to section 15-5017 in the development code. And then City Council, they consider anything considered by the Planning Commission where you make recommendation and they have the final decision power. They will hear that. They will also hear appeals from the Planning Commission. So there are some things that come to you specifically for recommendation to City Council. There are other things that come to you that you would have a final decision-making power over unless it's appealed. Generally, any type of permits can only be appealed by the mayor or the council member of the district in which the project sits. So that's the only time that they would hear something that you have on appeal that you would have final decision-making power over. And then they also hear direct appeals of environmental determinations made by the director, which we are actually seeing more of these days. Next slide. So then we have various types of entitlements and permits, and I feel like we could spend hours on each of these. So I just kind of want to go, I don't even think I'm going to go over all of them, but I want to focus really in on the ones that you see most often, which would be the development permit and the conditional use permit. You heard Phil speak earlier about the tables contained within the development code under the, I think it was the base and overlay district areas. He's giving me the nod. And within those tables, I'm just trying to bring them up so I can. You will have your use regulations, and depending on how an area is zoned and what somebody is trying to do in that area, it'll tell you that it's either a permitted use or a conditional use, conditionally permitted use, and that will determine the type of permit that you need, whether it's a development permit or conditional use permit. And this is where you hear staff come before you and make a recommendation to approve a permit, and they will tell you that all of the findings for the permit can be made, and they will generally go through those findings for you, and then you take comments from the public as well as any applicants or opponents. And based on the record, you get to decide whether those findings can or cannot be made. So I want to kind of just dive just a little bit deeper into the permit. Hold on. So, for example, under a development permit, so something that is allowed essentially by right, as long as the findings can be made. The findings that would have to be made is that the project is applicable, the applicable standards and requirements of the code are met, that it is consistent with the general plan and any operative plan or policies that the city has adopted, any applicable design guidelines adopted by the city council, any approved tentative map, conditional use permit, variance, or other planning or zoning approval that the project required, and then the Fresno County Airport Land Use Compatibility Plan. It's also consistent with that. Not every project will fall into a Fresno County Airport Land Use Compatibility Plan, just so you know. So based on those findings, you can tell that those are very objective, okay? So we have development standards that they talked about earlier, and if a project meets those, then generally it's very difficult to look back and say, you know, we can't find that it meets those. So as long as there's no information given to you in the record that shows that they cannot meet those findings, then the project should be approved. On the other hand, a conditional use permit, the findings are different. So a conditional use permit can only be granted if it's allowed within the applicable zoning district, consistent with the general plan. The proposed use will not be substantially adverse to the public health, safety, or general welfare of the community, nor be detrimental to surrounding properties or improvements. It's consistent with design, location, size, and operating characteristics. It's physically suitable for the site is physically suitable for the type, density, intensity. And then the proposed use is consistent with the Fresno County Airport Land Use Compatibility Plan. So in that situation, there's that kind of extra layer of the public health, safety, and general welfare of the community. That's one of those situations where if you wanted to say it couldn't meet that finding, we would need information in the record and stated on the record why you feel like that finding could not be made. So I wanted to focus on those, and then I will go over to the extent that I really know them, some of the other ones. So we also have temporary use permits that think about things like fairs and carnivals, you know, kind of pop-up stores or pop-up events. People would need to come to the planning department to be able to get a temporary use permit, and there would still be design standards essentially, or standards that would be applied to those uses to make sure that they are safe and compliant with our development code. Variances, and correct me if I'm wrong, but variances, they provide a mechanism for relief from strict application of the code where it would deprive a property owner of privileges enjoyed by similar property because of the uniqueness of a property. So oftentimes I believe we see these in allowance of setbacks, and Jennifer can chime in on when we would see these more often.
Yeah, so variances are really interesting tools in development or zoning codes in general. Really, there's something wrong with this piece of property, which makes it impossible to follow the rules that are in the code, right? There's something wrong with this piece of property. It's harder in Fresno than it is in other places. Usually you'll see this in places that are mountainous or have a lot of rivers running through it. There's a portion of the property that can't be developed for some reason. Maybe that it's the slope is too steep, or the type of soil wouldn't allow for you to build on it. So there's something wrong with this piece of property. Maybe Caltrans built the highway right through the edge of the property, so it's this weird kind of shape, and it's different than other properties. So that's when you typically would see a variance, and you see a finding that they can't follow the rules, so you have to give them some kind of modification, and it's not of their own doing. And that's the tricky part with variances. because you have to make a finding that it's not the property owner's fault that they can't make the site work for them, right? So if they just have it set in their head that they only want a 10-foot setback, but it's really 15, and they're trying to make an argument there's something wrong with the property, we really have to show that there is something really wrong with the property. We've seen a variance of that type in front of Planning Commission. I don't know if you remember the digital billboard on Highway 41. That was one of those, right? There's something wrong with this property because it's low. Well, all the other properties were low, right? So you made the finding that you can't have a variance for this, right? And so that is the kind of thing that a variance would be used for.
Thank you. I don't know how much you want me to go into the rest of these. I will say all of these permits that I looked up, they all have required findings attached to them. Anything that the planning department is recommending for approval, they have information on the record, and their record is, an application that is submitted, maybe it's an operational statement that's submitted by an applicant, or any other additional information the planning department may have requested to make those findings. All of that information is in the record and would be available to you. And then the one other thing I was going to talk about real quick is that the other area that you might see a lot of, or you might have come before you, are amendments to the development code. I think you all see that pretty often, or rezones or plan amendments as well. So, and those all have criteria attached to them as well that need to be met in order to request those.
Yeah, and we will see in the next couple months, we'll see a couple of amendments to text of the development code sections that the council has initiated that they'd like for us to review and bring forward. So you'll see those on a pretty regular basis. Hey, this is not a static document that just sits on the shelf, right? So land use and development is constantly changing, so we need to change the rules by which development occurs on a regular basis. It has to be a living, breathing document to work with the way development occurs in our community. All right, so the last section is one that I think is really important to focus on, and it may seem somewhat simplistic, but we have the use classifications and we have terms and definitions. Use classifications really tell us and define what a use is within single family. What is a low density, high density, attached, detached, or maybe you're in a public use. What's the difference between community and religious assembly versus colleges and trade schools, right? So they're use classifications. They define a use. Well, this is one of the very first things when someone comes to the planning department and says, I want to do this, right? This is the first place we look. Where does it fit in these categories? Is it a community garden, or is it an urban farm? Is it a conference facility, or is it some other kind of congregate facility, like a banquet hall, right? So what is it? And then where do they want to do it? So you start here. What is this thing that someone wants to do and wants to invest in our corporation, the city of Fresno, right? We want people to invest in the city of Fresno and to bring their resources here to our community. So they want to do this thing in our community. What is it? Is the very first thing we have to determine. Where does it fit, right? Once we determine that, then we go back to the section that Phil talked about. We go back to those use classifications. They want to do it in a specific place. Well, what's the zoning in that specific place? Is that a permitted use? Is that not a permitted use? Is that a conditionally permitted use? And what are the rules by which they need to follow to be allowed to do that thing, right? So if it's a restaurant, it can be open till a certain time of night or have alcohol till a certain time of night. If it's a bar, it has different rules, right? So how we define those come directly out of these use classifications. And then for more definitions and more terms, there is Article 68 are much more specific terms and definitions. And so we spend a lot of time just initially looking at, gosh, what is this thing that somebody wants to do? And then where can they do that? And what are the rules? And we go through that and try to follow the code as specifically as possible. We try to use as little discretion as possible, so making a choice. It's not about whether or not we like the shrubbery that's being put in or we dislike the shrubbery, right? It's about, is that what's required? And what kind is required? Where is it required? So that our team is really trying to be that objective observer to make sure that we're following the rules and we're treating everyone the same. But there are times when there is discretion, when there are findings that need to be made, and that's why we spend a lot of time on findings when we come to Planning Commission, because we want to make sure that we're fairly treating everyone who comes either to City Hall, just to us, to you as a commission, or to the City Council, that we're reviewing those findings as equally and fairly as possible. This was really a high-level review, so thank you for your patience tonight. We really wanted to give you a quick review of the development code and how to use it, but we do intend to have other workshops in the future. We've had one on findings that I think we'll have one again, just to help you with some of those trickier decisions. But if there are any specific sections of the code, I think some of those special uses Phil was talking about can be very beneficial to the commission to learn more about the code and how we apply it here at the City of Fresno. But any questions, any spots that you'd like more information on either tonight or in the future?
I think moving forward, I would like to have public and education on the findings.
Yeah.
The findings are good, yeah.
Yeah, that's a good one, because each section has slightly different findings that need to be made. Absolutely. Well, thank you all very much for your time and your patience tonight. We hope you enjoyed the presentation. And I do not have, when you get to my section, I do not have anything to report.
Perfect. All right, guys, well, it's 6:58. We'll go ahead and adjourn the meeting. Everyone, have a wonderful
Did
night.
we, just for, yeah,
For the
did we
public.
go out to the?
Do we have any unscheduled oral communications? Any individual on Zoom with their hand raised?
None at this time.
All right, we'll go ahead and it's 6:58. Meeting's adjourned. Thank you.
Amazing.